All right, Fifth and Sixth Amendment, they kind of really do run together. The Fifth Amendment has five important things in it. Four of them really apply to people who've been accused of a crime. You have due process, you have the right to a grand jury, you have the right to remain silent or not incriminate yourself, and why can't, what's wrong with me? Eminent domain. Oh, double jeopardy. Jeez. And you don't, once you are acquitted or said, once somebody says you're innocent, a jury says you're innocent, they can't go back and find new evidence against you and try to retry you. So, no double jeopardy. Okay. Authorities, first part of the Fifth Amendment I'm going to talk about is the self incrimination aspect. Authorities can't compel any person to be a witness against themselves. Now, that's what it says in the Fifth Amendment. Basically, all that says is that you do not have to admit that you are guilty. That is the government's job to prove you are guilty. It is the prosecutor's job to build a case against you. They have the burden of proof. You do not have to confess or admit guilt. It is the burden or the responsibility of the prosecutor working for the United States government to prove your guilt. Now, there is a close relation between this and having a lawyer. A lawyer is going to advise you on what to say, what not to say, and when to stop talking, what information to divulge. A lot of people don't understand the intricacies of the legal system, so it's important to have somebody that is representing your side that understands the legal system. Now, not everybody is given a lawyer. Escobedo versus Illinois is a court case that deals with one of these situations. Escobedo requested a lawyer but didn't get one. And in the process of being questioned by the cops, he confessed. But because he requested a lawyer to help advise him during the questioning process, his confession was inadmissible or couldn't be used in court. Miranda versus Arizona. Same kind of thing. Ernesto Miranda, did not have a lawyer. He was not read his Fifth Amendment rights. So he claimed that when he confessed, he didn't understand what he was doing. And so his confession couldn't be used. And now everybody has to have their Miranda rights read to them. Um, Everybody has to have their Miranda rights read to them if they're about to be arrested. Okay. New York versus Corrales. There is a public safety exception to the Miranda rights. It is acceptable for the police not to inform you of your rights when you are going to put other people in immediate danger. So if you're, and um, in this case, Corrales was he was robbing a supermarket, I think. The cops entered the supermarket, they stopped him, he started shooting, so they tackled him and arrested him, and he was frisked by the cops immediately because he had a weapon, and all of that was able to be used against him. So there is a public safety exception. So when you're going to put other people in danger, the cops can do what they have to stop you from doing whatever it is you're doing that's illegal. Okay. Sixth Amendment continued. Really, the Sixth Amendment deals with having a speedy trial and a fair trial, a jury of your peers, right? Gideon versus Wainwright was decided in 1963. The Supreme Court ruled that all defendants, even in state courts, have a right to counsel, that having counsel is a part of your fair trial process. Gideon was too poor. He asked if the state would provide him a lawyer. The state did not provide him one. Now, the lawyers that the states provide you often are not that great. They're very busy. Some states force um, lawyers to work as like do a certain amount of hours as a defense lawyer. Like, you have to put in at least one defense case a year to be readmitted into the state bar or reapproved into the state bar. So anyway, like the court said, Gideon was free to go because he was denied his right to counsel. Most cases are going to be settled between lawyers instead of a fair trial. Most people are encouraged to plea bargain. When you plea bargain, you are automatically admitting that you're guilty. Kobe, shush. Shh. Why is Kobe? Stop barking, Kobe. Okay. Most cases are settled between lawyers instead of a trial. So your lawyer, especially if your defense attorney is working for free, he wants to be done with that case as soon as possible. So what he's going to do is pressure you to take a plea bargain, which means you have to admit that you're guilty whether you really are or not. And you'll always be, a criminal, and you'll have to suffer the consequences of being a criminal. But they convince you that it's a good deal so they can avoid going to court and have your case over with. In federal cases, before your trial can begin, you have to have a grand jury. A grand jury is 12 people who review the prosecution's evidence that they think they have against you. So they're going to look at the case that the prosecution has built against you, and they're going to decide whether or not the prosecution has put together a viable case. Is there really enough evidence against you to even take it to the actual trial? So the grand jury is like a pre-trial trial. If the grand jury thinks that they have enough evidence against you, then they issue a bill of indictment. So after reviewing what the prosecution has against you, the grand jury issues an indictment. So if they don't even have a decent case against you, the grand jury isn't going to issue a bill of indictment. If you do have a bill of indictment issued, then you are going to go to trial. Then the next step is jury selection. Your lawyer's job is to get the best jury of your peers. If you are the defendant, your lawyer is looking for a jury that is going to be sympathetic to you. People who understand your situation. The prosecution wants to find jurors who remind or that are like the victim. Or especially if it's a murder conviction or a rape conviction, the prosecution wants to find as many people who are going to want to lock you up as possible. The whole jury selection process deals with preemptive strikes. You get a list as the lawyers. You get a list of about 100 potential jurors, their backgrounds, what they do, how old they are. You know all of their demographic information. And then you can strike people off of the jury list from the get-go just based on their demographic information. So those are called preemptive strikes. All trials must be speedy. Sometimes you don't want them too speedy, though, because if they're too speedy, then your defense doesn't have enough time to build a proper case or defense against you. They might not have a chance to to interview the witnesses in the depositions. They might not have enough time to review the evidence. But really, the one thing that your lawyer wants time to do is review depositions and talk to witnesses. The Eighth Amendment. Alright, the Eighth Amendment, it's like the SPCA out here, I swear to God. There they go. Alright, the Eighth Amendment is about cruel and unusual punishment. Cruel and unusual punishment really has evolved in this country, what we consider as cruel and unusual. We used to think that public hangings in the town square were fine. You know, you take your kids down to see the hanging of the criminal with a picnic lunch. Now we're starting to have conversations again about how cruel and unusual it is to give somebody the lethal injection. Do they feel pain for 20 seconds? Um, Cruel and unusual punishment doesn't just apply to the death penalty, it also can apply to things like prison overcrowding. Is it cruel and unusual to have too many prisoners in a prison? Is it cruel and unusual to deny prisoners drugs, like prescription drugs? Um, is it cruel and unusual to not give a prisoner dental work? It can apply to all sorts of things. The Eighth Amendment also mentions excessive bail. The whole point of bail is to guarantee that you're going to come back to court if the court allows you to go free while your lawyer is prepping for your trial. So if you're a millionaire, and bail set at $1 million, and you know that you can jump town and go live in Grand Cayman, will you come back for $1 million? Or will you just jump bail and never come back? If you come back, you get your $1 million back. It's like you're loaning money to the court to buy your freedom for a couple of months, and then you come back, you get your money back. And they hold some of it, but the bail needs to fit the crime. Okay, talking about death penalty real quick. Furman versus Georgia and Gregg versus Georgia are the two famous cases where the Supreme Court had to decide the constitutionality of the death penalty. In Furman versus Georgia, you had a situation where states really weren't making consistent calls on which kind of crimes and who would get the death penalty. Now, this was in the early 1970s. States weren't really consistent. Some states had rape as death penalty. Other states you had to kill. Had to be a multiple homicide. So what the Supreme Court did is they said, all right, we're going to stop the death penalty until states can be consistent and apply it, not just to minorities or not just to poor people, or not, we just need some consistency in how the death penalty is handed out. So if the state has death penalty, most likely it is only applied to capital punishment. Its capital punishment is applied to like premeditated murder, multiple homicides, things like that. So Furman was the first one, Furman first, FF, and that's when the Supreme Court said they had to stop. And then Gregg versus Georgia a couple years later, we're good to go again. So Gregg versus Georgia, you could go back to killing them. The Supreme Court confirmed that the death penalty doesn't violate your Eighth Amendment right to be free from cruel and unusual punishment, and states were more consistent on how they handed it down, if they handed it. Atkins versus Virginia. I think I might have. There's Roper versus Virginia and Atkins versus Virginia. In both cases, you can't give the death sentence to mentally retarded people, nor can you kill juveniles. And I think Atkins is the juvenile one. And I'm sorry, we're going to look at a death penalty fact sheet that has it up there, so you double check. But I think Atkins is the age one and Roper is the mentally retarded one. But you can't kill somebody who's a juvenile or mentally retarded. And really, unfair sentencing also applies to the Eighth Amendment, and this is the fact that DNA evidence has proven innocent people have been on death row, and a lot of people on death row have been exonerated, or have, the state realizes, oops, you really didn't commit this crime, and we were about to kill you for it. So you could see that actually fewer and fewer people are on death row since states have been using DNA testing on evidence. And that is it for Rights of the